Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in our CV140196, and I hope I get these wrong. I certainly don't mean to mispronounce, but is it Jin Ah Lee?
I believe that is correct, Your Honor.
Thank you. Versus ANC Car Rental Corp., General Motors Corp., and Hong Jun Jian. Each side is allocated 20 minutes for argument. The appellant may reserve a portion of that time for rebuttal if you wish to do so. You will need to keep track of the time using the podium clock, and that is your responsibility. Out of respect for counsel, we're going to ask anyone present, it looks like it's mostly folks associated with the court, but we're going to ask those present to make sure the cell phones are off or on vibrate. I can assure you, counsel, that we have read the briefs. We have conferenced the case this morning. We encourage you to keep that in mind as you present oral argument. These proceedings, I also need to advise you, are being recorded. They will be posted to YouTube. You may become a YouTube star as a result of today's performance. As you begin your argument, please state your name and the party you represent, and counsel for the appellant when you are ready.
Thank you. Good morning, Your Honors. May it please the court. My name is Scott Zerlot. I represent the appellant.
And is there an entity of the appellant? Excuse me. Go ahead. I'm sorry.
The appellants are the plaintiffs. Jin Ah Lee and Junggil Lee. Well, actually, Jin Ah Lee is the decedent. Junggil Lee and Sang Shul Lee are, well, excuse me, and Duxon Lee are the survivors. The record demonstrates that Mr. Kim, the appellant's attorney, did not skillfully prosecute the case. But that failure to skillfully prosecute the case is not the same as a failure to prosecute the case.
Are you familiar with any case that has gone 12 years without so much as a deposition?
Other than possibly in the context of antitrust, no. I am not.
And no case under Arizona law that I'm aware of has ever gone this long without actual prosecution.
Yeah, without question, this is an aberration. I believe there were some depositions. I believe there were some depositions of non-parties that were taken, but I don't believe any party depositions were taken.
In fact, expert witnesses were deposed, but no fact witnesses per se.
I believe that there were some actual witnesses to the accident itself that were deposed up in Chin Lee and Kayenta.
Mr. Jian, I believe, is tasked, if you will, with, under the plaintiff's theory, with the responsibility for the accident.
Yes.
Well, has Mr. Jian been deposed?
No.
So after 13 years, he stands still unopposed. He is a citizen of South Korea?
He is. And, Your Honor, Mr. Kim would argue that that occurred because he couldn't be located by his own attorneys. He doesn't reside in the United States. He resides in Korea. The record shows that Mr. Kim, in fact, provided information to Mr. Jian's attorney to assist him in locating him, but he was never produced for deposition.
How long ago was that information provided?
I believe that would have been provided after the bankruptcy case.
Was years ago?
Yes.
And he still hasn't been deposed?
And he still hasn't been deposed. And the last set of motions that were before the Superior Court included a motion trying to compel his attendance at deposition, but obviously that was mooted by the court's decision to dismiss the case for lack of prosecution.
This case is not dismissed for failure to prosecute. Is there any case that can be?
Certainly, I mean, the case law talks about abandoning the case, and when I look at the record, I don't see a case that was abandoned by the plaintiffs or by Mr. Kim.
I see a case that was maintained actively to present the specter of litigation with no actual litigation. I mean, it looks to me like there had to be a case pending at all time, and there was a lot of argument about keeping a case pending and keeping it pending with a certain lawyer for whatever strategic purpose there was. But I don't see any effort to get to the merits of this case. Can you tell me the best thing that plaintiff's counsel did in this case to actually reach the merits?
Well, Your Honor, he never got an opportunity to get to the merits of the case.
Wait. He represented in this case for a couple of years without even being a member of the state bar. He was unobstructed in his efforts to actively pursue, and you're saying he'd never had the chance?
Well,
Who deprived him of the chance?
I would say that the procedural delay associated with him chasing some rabbits down some rabbit holes that...
So his conduct precluded him from getting to the merits?
Well, his conduct was partially responsible. The General Motors bankruptcy wasn't his doing.
That's about 1/6 of the time.
That's true, Your Honor.
And what about the General Motors bankruptcy precluded him from lining up the other potential contributors?
Well, my understanding was that he perceived General Motors to be the target defendant, and the case was stayed case-wide.
File a motion to lift the stay, or did he wait a couple of years until there was a stip?
I do not know the answer to that, Your Honor. I do not know specifically what transpired in the bankruptcy court other than what was presented in the record in front of the Superior Court, which was a stipulation.
Counsel, let me ask you, I understand the position you're in, that you are here on appeal, a comparative newcomer as we are to this case. And you have acknowledged some things in response to questions by my colleagues about sort of what didn't happen, and you've done that head on, and that's to your credit. But we are here on an abuse of discretion standard. Trial court has enormous discretion, and had the trial court denied the request to dismiss, had there been an appeal, that would have been a discretionary call. But the trial court granted it. And help me understand how this trial court abused its discretion in a pretty unique case with a whole bunch of facts that aren't very flattering to your predecessor.
Right. Well, the abuse of discretion arises out of the record shows that there was an attempt to prosecute the case. It conceitedly was largely ineffectual, but he's not abandoning the case. He's not abandoning his clients. And ultimately, even if he is, that really should not result in penalty to the client, but rather some sort of sanction. And ultimately, I think the Superior Court could have just set a trial date and forced it to trial.
Well, and let me ask you about that. And the trial court could have done that. The trial court didn't. And the question is whether that was an abuse of discretion. But what, and with respect to the sanctions that you discuss, that sort of implicates what's sometimes called a culprit hearing, whose
Right.
fault is it, and the ultimate ruling here turns it into kind of a call the carrier sort of remedy as opposed to a remedy in this case. But if this isn't abandonment of the case, what would be? Help me understand, and this is to follow up on Judge Swan's case,
Right.
or question, I could picture somebody who files a complaint and then does nothing and it goes to a distant land and can't be found, but I think the court has more authority than just that, doesn't it?
Well, certainly, I think the classic case of abandonment is where a plaintiff's lawyer files a complaint and doesn't do anything to move the case forward, doesn't communicate with his client, doesn't file a motion to set, although in this case we did have scheduling orders with target trial dates, so the motion to set was kind of mooted by that. And ultimately, I think a plaintiff's lawyer is entitled to take his case to trial without conducting any discovery. I think it was the owner, the burden of him to advance his case to trial was met or attempted to be met by him agreeing to scheduling orders, which ultimately were stipulated by all parties to be bumped a couple times, which resulted in further delay. But that's a delay that's not attributable to to Mr. Kim or to the plaintiffs.
As I understand it, he didn't even agree to the scheduling orders in a timely fashion. They had to chase after him just for that.
Well, I think that he's been difficult, historically been difficult to contact and communicate from the East Coast. But other than that, I have no explanation for any delay in negotiating the scheduling
12 years
orders.
ago, communications to the East Coast were pretty reliable.
Counsel, I think that when, I'm not psychic, but I have a feeling that when the person speaking for the appellee stands up, we're going to hear that this isn't just about prejudice to the appellants in this, a prejudice from dismissal to the appellants. It's going to be about prejudice to them. And I don't want to lose your time without
Right.
you addressing
Right.
the possible prejudice to the appellees, to the appellees, if they had to go forward 13 years after this event occurred.
Right. Well, ultimately, and I don't mean this in a flippant sense, but they had the ability to go and interview witnesses. GM, with respect to the product liability claim, knows who its witnesses are, presumably. Any independent witnesses can have been interviewed at any point in time during the litigation. And ultimately, it's the plaintiffs that bear the burden of proof, and
I'm sorry, you said the point.
the plaintiffs ultimately bear the burden of proof, and any loss of evidence works to their prejudice and to the favor of the defense. And would you like me to address the Pro Hoc Vice issues?
That was actually my next question.
Okay.
In fact, when we look at the file, aren't Pro Hoc Vice oriented issues the bulk of the paper that's in this case?
Yes, they are. Although, from my perspective, the most important thing is saving the case for the client. And that's why I wanted to focus on that to start my oral argument. But Rule 38 gives the trial court discretion on whether to grant or deny a motion for admission Pro Hoc Vice. That motion was granted on January 28th, so Mr. Kim became a temporary attorney in Arizona. Rule 38 allows for that Pro Hoc Vice status to be suspended for non-payment of dues, but it's different from revocation, and Rule 38 provides that once he pays those dues and any late fees, he's automatically reinstated. Rule 38 also requires that the executive director of the state bar provide written notice to the out-of-state attorney and a certified copy of written notice to the superior court that dues haven't been paid and that the attorney is suspended. Mr. Kim's affidavit in support of his attempts to get reinstated made clear that he never received such a notice, and my review of the index on appeal doesn't reveal that such a notice was ever filed with the court, and I've never seen any such notice.
But he knew.
Well, he knew after he was contacted by Mr. Bowman, or Mr. Bowman contacted the court. I'm not sure how it transpired, because Mr. Bowman had checked with the state bar to see what his status was. That's when he learned.
One would think that having practiced in Arizona for 2 years without even trying to be admitted, he might be on his toes when he gets actual notice and not wait for a certified correspondence from Mr. Phelps.
I certainly would have been on my toes.
And yet I have to point out, his name appears on the brief before this court when he knows that he is not admitted in Arizona, and yet he has filed a brief in the Court of Appeals of Arizona. How can that be justified?
Well, with respect to the decision to not reinstate him or to revoke his Pro Hoc Vice status, the trial court has to find the deliberate wrongdoing. If he's unaware,
Well, go ahead.
if he's unaware at the time of his suspension that he's not admitted.
Well, he's a lawyer.
Right.
It's his responsibility to read the rules, and I suspect that if you were going to just go into some other state and start practicing law, you might check those. So it's not an accident that he didn't get admitted for 2 years, and it's not an accident that now, knowing he is not admitted, he's still filing briefs in the appellate courts of this state. How can that be overlooked?
Well, I guess ultimately it shouldn't work a prejudice to the plaintiffs. Even if this court decides to affirm the revocation of his pro hoc vice status, that shouldn't be justification for dismissing the case.
Well, malpractice claims do exist because sloppy or bad conduct by lawyers can damage their clients' interests. I mean, that is a pattern in the law that's well established. And I understand the reluctance, especially in Arizona, that our courts have to inflicting the wrongs of the lawyer on the client, but there are limits. Why is this case not over the limit?
The record reveals, again, ineffectual attempts to get it remedied. He was not successful.
By whom?
By Mr. Kim. By Mr. Kim. The affidavits that were submitted, along with the motions for reconsideration, indicate, especially the affidavit by Mr. Savoya, indicates that they just weren't finding success in associating local counsel, which obviously made it difficult for them to file their pro hoc vice papers and to comply with state law.
Wait. Because they couldn't find local, you mean to support the pro hoc vice?
Yes.
You're not saying to actually make the filing?
No.
And why couldn't they find local counsel?
Well,
I think we're up to 20,000 plus lawyers in the state.
I actually have absolutely no idea, and it's not reflected in the record. I have my own suspicions, but it's probably irrelevant to
I don't want
this
to put
case.
you to that. Yeah.
Counsel, let me ask you. Mr. Kim's position is that he had no idea he needed to annually renew his pro. I mean, doesn't the pro hoc vice application tell him he needs to do that?
His position was that he believed that at the time his associated local counsel, Mr. Trayborn, was filing all those, and it appears that he was, for a period, just didn't file in that last year.
And I understand what you're saying, but and the state bar may have a role in it, and local counsel may have a role in it, but ultimately the buck stops right with him.
Absolutely.
And you indicated that the pro hac by itself shouldn't justify the ruling that the Superior Court issued dismissing the claims, but there's a whole bunch more than that that I believe the trial court relied on. What is the best case that you know of, best published case from your perspective that supports there's an abuse of discretion?
It would be the Spear case and the, bear with me 1 second. The Spear case, and then with respect to the dismissal, it would be the Cooper and Southern Union cases.
Thank you.
I have about 3.5 minutes left. I'd like to reserve the rest.
Thank you, counsel.
Thank you, Your Honors.
It's my understanding that one of the named appellee's attorneys is going to represent for the bulk of the argument, at least?
Yes, Your Honor. Let me explain. May it please the court. I am Tom Klein. In 2003, I was retained by General Motors Corporation to represent them on the claim that the 2003 Malibu was defective. Obviously, General Motors Corporation has gone through some changes in the years that have passed since. I'll spare the court, it's in the record, but I'm here on behalf of GM just to simplify things. We also accepted a partial tender from Alamo Rent-A-Car because there was a claim against them that they rented a defective vehicle, so we're defending the design of the vehicle. There's a separate claim against Alamo Rental Car that the woman at the counter at the Las Vegas airport should not have rented them that car. So Mr. Medcoff, Tim Medcoff, is here on behalf of Alamo on those independent claims. When Mr. Gion, the driver, was renting the car in Las Vegas, he checked that box for additional insurance coverage. So Mr. Spies, Peter Spies, is here representing the driver because he checked that box for that additional insurance coverage. So that's the lay of the land over here. I'm going to start, and what I want to do is focus on the discovery against my client, GM. Frankly, it won't take very long. I've been practicing a little over 30 years now. I have not had any other cases that have come anywhere near lasting this long. Now 12 years. June 1st of 2003 was when the wreck happened. August 11th, 2003 is when Mr. Kim filed his first lawsuit in Judge Teelborg's court down the street in federal court. It's been over 12 years since all that started. Judge Nichols' order from January 23rd, 2014, 22 pages long. I'll defer to you, gentlemen, as to how often you see a trial court order that's that long and that thorough in its discussion of the facts and the law. But just on the face of it, does not appear there's an abuse of discretion there. Interesting thing is, looking at the appellant's briefs, their opening brief and the reply brief, there's barely even any mention of Judge Nichols and no discussion whatsoever of her 23-page order and why it's wrong or why it's an abuse of discretion. Here's the discovery against my client. Number one, they served what amounts to 300 requests for production on my client in 2007. You can find it in the record if you want to look at the discovery at A as an apple. This is the appendix they attached to their opening brief, A0680 through A1040 through 1060. There's actually 82 numbered requests, but some of them have subparts. Number 70, for example, by itself has 43 subparts. ARCP 34B limits parties to 10 specific requests.
Was that filed by Mr. Kim?
It was filed by Mr. Kim.
And you were just getting to the 26.1 issue?
Yes.
Would you please?
Yeah. So we've also filed disclosure statements. But in 2007, Judge Newton, thank you. Judge Newton at the time said, look, that's too much. Do disclosure statements and then talk about what you really need. We finally get a disclosure statement from plaintiffs about 5 months later. We also served a disclosure statement. Our third supplemental disclosure statement can be found at A1233 through 1243. We disclosed over 82 categories of documents: the design and testing information for the brakes on the car, for the roof on the vehicle, for the interior padding in the vehicle, articles about anti-lock brakes that show, for example, that rollover accidents actually increased with cars with anti-lock brakes, which is why in the early 2000s GM started offering that as optional equipment. There's not even any indication that the driver stepped on the brake here. That's based on the SDM, the sensing diagnostic module in the car that also showed the driver was going 93 miles per hour at the time he lost control of the vehicle. But we disclosed that, and we also disclosed 4 experts. That's at A0680 through A0690 to reconstruct the wreck, to show that if Ms. Lee in the back seat had been wearing her seatbelt, she would not have been ejected, would not have been killed. She would have had the same experience that the other 3 people in the car had, which is bumps and bruises, and they walked away from what was a violent rollover crash. Did they try? So they reserved that discovery in 2012. We had to file a motion for protective order, which is the other thing that was heard by Judge Lodge and granted, again for the same reason. It far exceeded what was the requirements are under ARCP 34B. Mr. Kim at that hearing said, no worries, I'll pare it down. And that never happened. There was one time when he tried to notice a 30B6 witness from General Motors. The deposition notice can be found at A1096 through 1097. 2 categories. Number 1, produce a witness about the subject accident. There's nobody at GM that has personal knowledge about the subject accident. We disclosed 4 experts to talk about what's going to happen on the subject accident. Category number 2, somebody to discuss, quote, all of the engineering issues in plaintiff's 300 requests for documents. We said that doesn't comply with 30B6. You have to be specific about what you want. And Mr. Kim said, okay, I'll look at it. Crickets. It was never reserved. There was never another attempt to depose GM.
How far into this litigation were you at that point?
That was in, ironically, February of 2012, when his pro hoc vice had been suspended a month earlier on January 13th of 2012.
Thank you.
There was some activity in 2012 until we discovered all the issues with his pro hoc vice and the fact that he had not been full in disclosing to the state bar, for example, a legal malpractice judgment against him, an additional censure against him by the state bar of the state of New Jersey. And that's when we filed the motion to disqualify him in April of 2012. But the record is clear on that. You guys have read the briefing. I don't want to belabor what's already in the record. Prejudice. I have to speak a moment on prejudice. I mean, obviously, with the passage of 12 years, there's going to be problems. The vehicle has been in a parking lot at the Albuquerque airport for most of those 12 years. It's covered in plastic, but things decay over time, especially when they're exposed to the elements, and the temperature extremes are a little bit greater in Albuquerque than they are here. It gets colder there. The witnesses, Mr. Gion, the driver, who at the time was a 23-year-old, perhaps impetuous college student who's trying to pass 4 vehicles on that rural road outside of Kayenta, headed to the Grand Canyon, and hits 93 miles per hour in the course of trying to do that, in the last 12 years has finished college, gone to and finished medical school, gone through and finished a residency, and is now a 35-year-old medical doctor in South Korea. So GM trying to try this case and show that really what happened here, why it rolled over, was driver negligence. Instead of the jury seeing this young 20-something college student who might be apt to do something like that, is now going to see a mid-30s medical doctor from South Korea, assuming we probably can get his deposition. But the other 2 people in the car, I have no idea where they are. We haven't spent money to keep track of these people as the calendar has gone by and more 12 years have passed. There were 2 eyewitnesses identified in the police report, 3 eyewitnesses. We deposed a couple of them back in 2012. They don't really remember. There's another one, Brian Hamilton, that we can't find anymore. We deposed Gerald Johnson, who was the DPS officer who investigated the wreck. He doesn't remember anything. He said, well, here's my police report. It was a long time ago. Those depositions happened only 9 years after. Another 3 years have passed. All that has gone on, literally, since Mr. Kim's ProHawk was pulled in August of 2012 is a fight about his ProHawk visa application. Now, you would think, for example, in June of 2013, when we finally say enough is enough and we file a motion to dismiss the case for lack of prosecution, that maybe the light bulb would go on. And they would then say, okay, here's a pared down 30B6 notice for GM. We want to depose somebody. Never filed. Here's a pared down request for production of documents. We've looked at what you've disclosed. It's not adequate. Here's a pared down list. Never done. Nothing. No discovery is done to try to pursue this case and bring it to a conclusion, a resolution.
What about plaintiff's disclosures?
They filed a disclosure back in federal court, in Judge Teelborg's court in 2004, that listed the witnesses that were on the police report, listed the plaintiffs, and listed a couple experts. They have an accident reconstructionist. They have a design person named Shane Richardson from Australia, with whom I'm very familiar. I've done General Motors work since 1989, so I know the experts on their side. We tried to depose Mr. Richardson. It was a shell game. There's a letter in the file.
Was there ever a 26.1 disclosure statement?
From the plaintiffs?
Yes.
I'm describing it. They disclosed these witnesses.
That was in federal court.
They did another one. They filed one in, I think, February of 2008. That's after Judge Newton said, do disclosure statements instead of serving this voluminous discovery. 5 months later, we get, and basically it's a copy of what had been filed in Judge Teelborg's court in 2004. And with the same people, there's an economist saying that she would have become an interpreter and made a lot of money, but there's no claim that she was providing any support to the parents, who we know from other investigation are independently wealthy. Mr. Lee, it's in the record, owns a clothing distribution company that operates throughout Southeast Asia. So there's no indication that she would have ever provided any support to them. They never, for example, got a personal representative appointed for the estate, Mr. Jung-Go Lee. We litigated that in New Jersey, got that dismissed, the claims of the estate dismissed, had to file the same motion again in Arizona, and again it was granted. Mr. Lee was dismissed. The estate claims are gone. So yes, there were some disclosures of witnesses by the plaintiffs, but there's no indication they did any work on the case after 2004, because the names never changed.
Did Mr. Kim ever defend the delay on the basis of the appellees refusing to work with him, refusing to respond? Did he file any motions to compel
Kinda. In the spring of 2012, he filed a motion to compel Mr. Gion's deposition. Mr. Spies can address it in more detail, but he had withdrawn the notice. So he's now filing a motion to compel a deposition where he had withdrawn the notice for that same deposition. So that motion never went anywhere. But beyond that, no.
It took from 2002 to 2012 before he filed a motion to compel a deposition that he'd already withdrawn the motion on? The notice on?
Yes.
Thank you.
Yes. I've talked for almost 12 minutes. I'm going to yield the rest of my time to my co-counsel. They've done nothing to pursue this case against GM that really was serious.
Good morning. Your Honor, I just want to clarify one thing on behalf of...
Go identify yourself.
Yes, of course. Tim Medkoff on behalf of Alamo ANC Car Rental, DBA Alamo Rent-A-Car.
Thank you.
There was one motion to compel in 2012 that Mr. Kim also filed against my client for allegedly not producing documents, and I use quote marks because the documents he was seeking for me to compel I had produced in October of 2008, dealing with the rental agreement.
4 years prior.
4 years prior. And this is the same issue that you'll recall in the reply brief that led to an amendment being made, because there was an allegation in the original reply brief saying that Alamo had not produced documents in this case, which is simply not true. So there's that issue as well. So I wanted to raise that to the court's attention. Obviously, from my client's perspective, I'm not going to, I'll be brief. I'm not going to repeat what Mr. Klein said on behalf of GM. But there's been multiple delays in this case that were the product of Mr. Kim pursuing, as Mr. Zerlach said, chasing rabbits down rabbit holes. And the standard that Mr. Zerlach has referenced is an abandonment of the case. That's not the standard that the Court of Appeals needs to look at and that the trial court needs to look at, as set forth in our moving papers and our brief. There's additional standards that apply. On page 22 of our answering brief, appellate courts have upheld dismissal for failure to prosecute where plaintiffs have prejudiced defendants through mere delay, by unreasonably delaying discovery, by failing to comply with court orders, and through extended periods of inaction. I submit to you all of those apply in this case. In addition, there was discovery, and these documents are in the record, that were GM served on plaintiffs and demanded multiple times, hey, you haven't produced that information. We need that information. Please produce it. Again, those requests were ignored by Mr. Kim. There was also requests for information related to the expert witnesses that the plaintiffs had disclosed. Give us a backup documentation that the experts are relying upon to support their reports or their opinions in the case. Again, ignored, never produced in the case. So this has been a case, unfortunately, and I don't say this flippantly, but this case started before my 11-year-old son was born. And so every time I talk about this case, that's my frame of reference for this matter. And I think about how much he's changed in 11 and a half years. And that's the sort of prejudice that we're going to have to deal with if you were to remand this case back to the trial court, because of the amount of time that has passed in this case. There's been significant changes with respect to the witnesses that would be produced and the evidence that would be interpreted by the jury. And it would, as Mr. Klein said, it would unfairly prejudice our clients to be put in that position after this passage of time, especially when, if this case doesn't justify dismissal for abandonment, violation of court orders, and all the other things that Judge Nichols set forth in her ruling, I don't know what does, Judge. If you don't have any questions, I'll go ahead and sit down and be quiet.
Thank you.
Thank you.
Your Honors, Peter Spies on behalf of defendant Jun Hong Juan.
Juan is how you pronounce that?
I'm not exactly sure. It's either Juan or Juan. Just a couple quick points, and then I'll make myself available for any questions that you might have. One of the difficulties that I had as Mr. Juan's attorney was the delays caused by the appellants in filing first in federal court, then taking it through the Ninth Circuit, then the U.S. Supreme Court, then going to New Jersey, where motions had to get dismissed because there was no connection to Mr. Juan in New Jersey. Years passed, and that was one of the reasons why I had difficulty contacting my client, because there was no reason to contact him while we were on appeal in the Ninth Circuit or the U.S. Supreme Court to discuss to my Korean client what was going on in the procedural halls of the U.S. federal courts. When Mr. Juan's deposition was requested, I had lost touch with him, quite candidly. And so I was also aware, however, that he was a friend of the family, being the appellants. And so I asked Mr. Kim whether or not he could assist me in finding Mr. Juan, and he did, and I was able to speak with my client. There were 2 occasions where I lost touch with Mr. Juan, and each time I was able to get a hold of him within a month, both time with Mr. Kim's assistance. And so if there's any delay attributable to my difficulties in communicating with Mr. Juan, they would total 2.5 months. Mr. Juan's deposition was noticed for 2012. However, as an affidavit which I filed with IR 113 as Exhibit A, as well as an email that was attached to our response to their cross motion to enforce plaintiff's discovery demands, I demonstrated that that deposition was vacated during the Kayenta depositions, which occurred in March of 2012, because the appellants wished to be personally present for Mr. Juan's deposition as well as the 30B6 deposition of ANC's experts. Following
when you say personally present, you mean that would have required them to fly in from South Korea to do this?
Yes, that is correct.
And that created what problem for you?
Didn't create any problem for me. For them. It didn't create a problem for them. They're the ones that suggested that they wanted to fly in from South Korea to be personally present for the depositions. And that was the reason, since Mr. Kim did not know their scheduling at that point in time, that was why the depositions were put off with regard to Mr. Juan, were vacated to be rescheduled at a latter date. I believe the 30B6 depositions of ANC's experts were also vacated for 2 reasons. One, because they wanted to be the appellants wanted to be personally present for it, as well as some issues with the 30B6 designation that ANC was facing, similar to the issues that GM was facing. I brought this all to Judge Lodge's attention during the August 20th, 2012 hearing. That would have been at at the supplemental, at the appendix of 1399, as well as the fact that the deposition was vacated, and I brought that to the court's attention at A1400 through 1401. I might also point out the fact that Jin Ali is no longer a party to this action. It's really just the parents who are suing for their loss of their daughter. As Mr. Medcoff pointed out, Mr. Richardson was never deposed. That was because when the time approached for his deposition, that's the plaintiff's, or excuse me, the appellant's own expert, we were informed that he would not be available at the date and time which had been designated, and so we would have to renotice it, come up with another time. And this was, I should also point out that the appellants themselves were involved in this case. In November of 2012, sometimes the years have gone by and it's difficult to remember, Mr. Kim filed an affidavit where he expressly stated that his clients were personally involved at every stage of the proceedings.
Counsel, we need you to wind it up.
I will. I'll point out one last thing, Your Honor, and that is the order that the appellees went to the trouble of having translated into Korean and served upon the appellants personally in Korea expressly set forth to the appellants, not through their attorney, but directly to them, that their case would be dismissed if they didn't hire local counsel within 45 days from the date of service. And yet nothing happened. So they were aware of what was going on. Thank you very much. If you have any questions, I'll answer them. Otherwise, I'll sit down.
Well, Your Honors, I don't really have anything to add to what I briefed and what I've already had to say, but I'll be happy to answer any additional questions you might have.
I think we're good.
Thank you very much.
And counsel, we all have been for your standing today, so we do understand. Counsel, we are going to take this matter under advisement at this time, and our order will issue in due course. Thank you.